All right, let's get started. Hello, everyone, and welcome. I'm Katie Kreider, and I'll be your host for today's session, Immigration Strategy in 2025, What HR Leaders Can't Afford to Miss. We're thrilled to have you with us today for this timely and critical topic. Before we dive in, a quick housekeeping note. If you stay with us for at least 50 minutes, you will be eligible to receive one SHRM credit, so that will be sent to your inbox then afterwards. We'll share all the info you need to claim for that credit at the end of today's session, so be sure to stick around. So now on to our speaker, someone who needs no introduction in the immigration world, but is getting one anyway because her expertise is just that impressive. Jennifer Bem is a highly regarded U.S. immigration attorney and a partner at Berardi Immigration Law. She brings deep expertise in employment-based immigration and works with U.S. and global business, HR teams, and mobility professionals across industries, from tech and healthcare to engineering and logistics. Jennifer helps employers navigate sponsorship strategies, manage visa petitions, and guide companies through the green card and perm process. She also works with individuals pursuing options like V1 and TN visas. Beyond her political client work, Jennifer teaches business immigration law at SUNY Buffalo School of Law, along with AILA Liaison Committee, and frequently shares her insights with national media and professional associations. We're incredibly lucky to have her here today to walk us through what's changing in immigration and what HR needs to do to stay compliant and competitive. A little note as well, we will be sending out the PowerPoint and the recorded presentation this afternoon. So with all of that, now let's get to the person you all came to hear from. I'm going to hand it over to Jennifer.
Katie, thank you so much for that very kind introduction, and welcome to everybody who's tuning in today. Thank you for being here. This is a hot topic in 2025 with the current change in the administration. Lots of immigration things happening, and I'm sure you see lots in the headlines. So I'm here today to give a brief overview of how our system works. We're also going to discuss some of the basics in I-9 compliance, and I'm going to give some tips for HR professionals and business professionals when they are dealing with foreign nationals. Katie also shared with me that she's going to send a survey out afterwards. We could have tons of immigration related topics. So please share what you're interested in, and we can host additional webinars as well. So with that, let's dive in. Oh, actually, Katie, do you want to jump back? This one was your slide. Sorry.
No worries. MP, just real quick about MP. MP has been in the business for 20 years. We are headquartered in Beverly, Massachusetts, and we streamline operations from HR, payroll, and compliance solutions. Our goal is to try and make your life as easy as possible, to not replace your team, but to keep your team as advanced as possible. So it will empower your team, empower your clients, and we focus on business goals while MP manages the critical HR update. So we get to partner with people like Jen and make sure that you're staying compliant and proactive as much as possible. So we offer technology solutions, HR solutions, and recruiting solutions. So the HR services team is fantastic. You get to work with an HR consultant who will work with your team directly and customize the solution and be proactive with learns your business and helps you stay proactive. So part of being proactive is getting to work with people like this and put on webinars like this. So I'm gonna hand it back to Jen, and we'll talk and we'll send more info, like Jen said, in the survey at the end. So thank you.
Well, and thank you to MP and your team for having me today. I'm excited to be here. Again, I'm Jennifer Bem. I'm a partner with Berardi Immigration Law. We are headquartered in Buffalo, New York, with satellite offices in Newport Beach, California, as well as in Toronto, New York City, and in London. I also teach immigration law at UB Law School here in Buffalo. Our firm is turning 25. We turned 25 last month, so we are so excited to, we had our 20th anniversary, and we work with multinational companies and individuals, primarily with employment-based immigration as well as family-based immigration as well. So our website's below. I'll also be sharing my contact information at the end of this presentation. And with that, let's jump in. So The U.S. immigration system is one of the most complex immigration systems in the world. Generally, it does require sponsorship. So outside of individuals who are coming here as temporary visitors, to come on any sort of permanent basis or to work in the United States, we generally have 4 tracks. The family-based track is for permanent sponsorship only. So again, outside of visitors, individuals who are immediate relatives of US citizens or green card holders, like a spouse, children, or siblings, can be sponsored by their American citizen relative for a green card, which is permanent residence to live and work in the United States without conditions. The employment-based track is what Berardi immigration law primarily specializes in, and there are 2 ways to come into the United States to work. We're going to discuss temporary or non-immigrant visa categories. We'll go through just a handful. There aren't a ton of ways for individuals to lawfully come in and work in the United States when they're being sponsored by employers, and we're always trying to fit a circle into a square. So we'll talk about some of those alphanumeric categories today. And then in the same vein, employers can also sponsor foreign nationals for green cards, which is a term that's used interchangeably with lawful permanent residency status. This is not citizenship. It's a step before obtaining citizenship. And it takes a very, very long time to get a green card. So we'll go over a few details about that. The hottest track, you're hearing about it in the news every day, is the humanitarian track for individuals who are coming into the United States. That involves asylum and refugee law, and the difference between the 2 of those is whether the applicant is applying from within the United States, so they're already here perhaps, they might make an asylum claim against to stay in the United States because conditions in their home country are not good and they are in a danger, to put it simply. And then we also have a refugee track of immigration, and that's for individuals who are outside of the United States and go through processes for security clearances and screening. When they are approved, they are then allowed to enter the United States as intending immigrants. And we have lots of refugee programs. The Trump administration is pausing those quite a bit, so we're not seeing as much of that today. And then we also have temporary programs. And this is one of the hot topics right now under our current immigration system, because the Trump administration is really trying to curb these temporary programs. We had, under the Biden administration, a program that would parole individuals from certain countries into the United States. It was called the CHNV program. That was for Cubans, Haitians, Nicaraguans, and Venezuelans. And the goal behind that program, when it was established, was to try and control the influx of migrants coming in at the southern border. That has been ended. And we also have another program called TPS, or Temporary Protected Status, for certain designated countries. And that includes Ukraine, Nicaragua, Haiti, Venezuela, and a host of other countries. However, again, the Trump administration is ending TPS benefits for certain countries. We're not going to cover those a ton, but this is relevant when we get to the I-9 section, because the ending of these programs is impacting employers and who they have on their team, especially when it comes to I-9 re-verifications. So we'll touch on that briefly, and I'll explain a little bit more about those documents. And then finally, the 4th track of sponsorship, if you will, is called the Diversity Visa Lottery. And essentially, this is a green card lottery. The goal behind the Diversity Lottery was to give individuals from underrepresented countries in the United States an opportunity for a green card. It's just a tiny sliver of the immigration pie, if you will, but every now and then we do get contacted by someone who was selected in the Diversity Lottery, and they go through an application process to obtain a green card. So when I'm talking about employment-based immigration especially, I like to use a metaphor called the 2 trains metaphor. On one hand, one train is going to represent temporary visas, and each train car, pursuant to this metaphor, is representative of a different alphanumeric visa category. We'll chat about those in a minute, but we have visitors, we have international students, we have the H-1B visa that we'll chat about today, the L-1 for intracompany transferees. Similarly, on the non-immigrant train, these are always going to be categories that have an expiration date. You may also see TPS individuals. So the non-immigrant train is representative for individuals who are here in a temporary status. And the key to know is that their ticket, if you will always have an expiration date. Okay. And to renew that ticket and to continue riding on the train in the United States, they either need to renew their current ticket. Sometimes that's possible, sometimes it's not. Perhaps they want to jump to a different train car. Again, sometimes possible, sometimes not. Or maybe they want to make a jump to the other platform to catch a green card train. That is going to take a much longer ride into the United States. That's the train that's going to take someone off into the sunset to live and work without restriction in the US. But keep in mind, to get that ticket requires a lot of time, a lot of money, and often sponsorship, again, by an immediate relative or perhaps their employer. So keep this metaphor in mind. Individuals who contact us or employers who say, oh, we're interested in hiring so-and-so, they want to get a green card. How can we go about that? More often than not, we are first looking at a temporary visa category for that individual. Why? Because it's a lot faster to obtain a temporary non-immigrant visa rather than immediately applying for a green card, which can take years. So on this slide, I've listed some of the most common non-immigrant visas. We're going to go over a few of those as they pertain to HR professionals and some of our listeners, I'm sure. Businesses often sponsor H-1B visas. That is for professionals. Sounds like a great category, but there's a catch, and we'll get to that in a few moments. Companies that have operations both abroad and in the United States may be able to leverage the L-1 visa category for what we call intracompany transferees. So this is a category that allows you to transfer key personnel who've been with your company abroad into an affiliated office in the United States. Great category. We also have seasonal workers who come in under the H-2A for agricultural workers or H-2B categories, which may be more seasonal, like hotel workers and more seasonal businesses. There's the O1 category for individuals with extraordinary ability. This is leveraged most often by Hollywood and major motion picture productions, but really anybody who has a high caliber of a skill set that can be documented properly to satisfy government agencies who are reviewing these applications might qualify for an O1. And then our firm also works with a lot of industries and teams in athletics. And so the P1 is a category we use for athletes and their coaches. We also look at treaty-based work visas. So if you are hiring Canadians or Mexicans who qualify under certain occupations, the TN category is a great fit. Australians, we love Aussies. They have their own category that's very similar to the H-1B category. So Aussies are eligible for E3 visas if they have a bachelor's degree and they are professionals working in a specialty occupation. And then two other treaty-based categories are for Chileans and nationals of Singapore. They're eligible for the H-1B1. So that can sometimes be a pleasant surprise when we're working with a client and we find out they have that nationality. We'll work with one of these treaty-based visa categories. Again, visitors or training only, that would be the B1 or B2. So individual business owners are, business visitors who are coming in for conferences, business meetings, trade shows. Perhaps they're exploring investment opportunities in the United States. They're often admitted in the B1 professional visitor category. And we also have the F1 and M1 categories for academic students. Sometimes students have very limited opportunities to work in the United States, but it's not a true work visa like those other categories I just went through. It does allow work opportunities, but technically under the immigration regulations, these are considered for training purposes. And then, of course, dependent family members can accompany the primary visa holder. Some of these categories allow spouses to work and others don't, but they can all go to school, including children. And the cutoff dates for dependent visas for family members is age 21 when it comes to immigration, not 18. So if a family is coming in and their child turns 21, make sure the family will want to make sure that they have some other basis lined up for that child to stay. Oftentimes it's the F1 so that they can continue going to college. And again, remember, these are all representative of different train cars. Back to that metaphor. These will always, always, always have an expiration date and a set of rules and restrictions attached. So when we're talking about our employment-based immigration system, here often the way the system works is that an employer will file a petition. That means the employer has a bona fide job offer for an individual. They are requesting a certain visa category, and I recommend that you engage immigration counsel to assist with that because it's not always easy or clear-cut to get those approved petitions. And if the individual is outside of the United States, they will then take that approved petition, file a visa appointment at a U.S. embassy or consulate abroad. The immigrant will attend their visa appointment, get a stamp issued into their passport, and then they can apply for entry to the United States. Once they're here, they don't necessarily need to leave, but they do need to maintain the terms of their status by either changing to another visa category if possible, or more often what we see is they will request an extension. So I thought it'd be helpful to take all of my HR listeners and global mobility teams through a sample situation that we often see in our world. So I'm introducing our characters. We have Ravi. Ravi is a recent graduate of a university. He is an Indian national, and he has a job offer with Bison Software Solutions, Inc. The HR contact from Bison Software reaches out to me, and I'm going to explain the process of how Ravi is able to work with his graduate work permit. So as a recent graduate, Ravi is eligible to apply for what we call OPT work authorization. OPT stands for Optional Practical Training. And Ravi is going to be eligible for a 1-year period initially. And when I do some digging and ask some questions and look at his paperwork, I'm going to find out that he was a computer science major, which makes him eligible for an additional 2-year STEM OPT work authorization. He can't apply for that until closer to the end of his OPT session. But overall, what I'm going to tell Bison Software is that Ravi has a full 3 years of open work permit where he does not technically require sponsorship in the sense of needing an immediate visa application. So for employers who are well connected to their local universities and they're constantly getting job applicants who are saying, no, I don't need work authorization, oftentimes what they're referring to, they being the individual applicant, is they have an open-ended work permit called OPT or possibly STEM OPT if they're already a year into it. And technically, to onboard them, they don't need immediate work authorization. Now, for my HR professionals who are listening, keep in mind that usually they will require sponsorship or request sponsorship if desired. And a U.S. employer does not have an obligation to sponsor someone for work authorization. So going back to that train metaphor, Ravi's riding in the F1 OPT train car. He's going to renew his OPT to obtain that 2-year additional STEM OPT benefit. That's a separate train car. But this begs the question, well, what happens when Ravi's STEM OPT benefit expires? Well, that brings us to the next option. So Bison contacts me and the HR lead says, listen, we really like this guy. He's got 1 or 2 years left of OPT work authorization. How can we keep him here? Can we sponsor him for a green card? And my answer is going to be, well, yes, you technically can sponsor him for a green card. But as we'll get into it later, that's not going to immediately solve keeping Ravi on your payroll and being able to engage him in work authorization. Really, going back to that list of non-immigrant visa options, probably the only option available is going to be the H-1B visa for specialty occupation workers. What does that mean? The H-1B is for individuals who have a professional job offer in a field that requires at least the attainment of a bachelor's degree or equivalent work experience, or higher. So a professional job offer. An administrative assistant probably isn't going to cut it, but this is often used in engineering, medicine, law, business, education, the arts, business sectors, and we look at the job, we look at the duties that are required, we look at the government's publication and encyclopedia of jobs, if you will, align it to one of those and prove that the DOL deems this industry a specialty occupation. Sounds great. What's the catch? Well, the problem is that Congress limits the number of first-time H-1B visas that they will issue each year. And those numbers are statutorily set at 65,000 for bachelor's degree holders, plus an additional 20,000 reserved for foreign nationals who have a U.S. master's degree or higher. Okay, to put context to that number, there were over 400,000 applicants who have historically applied over the last 4 years for one of those 85,000 visa slots. So the odds are not in an employer's favor nor the individual's. Kind of taking a step back, how does the H-1B lottery work? Well, each year in March, we work with employers, we get them registered on an electronic system that U.S. Citizenship and Immigration Services uses to host this lottery system. Employers can then list their individual applicants that they want for consideration in the lottery. And by the end of the month, and this will be late March by now, there will be a random selection process. Now, kind of a side note to that, there is proposed policy changes within the Trump administration. We have yet to see the details, but the administration is, right now, the lottery is completely random. The administration is proposing to change the lottery and give extra favor to those applicants who are going to be paid a higher wage rate. This is a bit concerning because we often see individuals like Ravi, who are recent graduates and probably not at the highest range of the salary cap within their industry. If the Trump administration changes the way the H-1B selection process goes to favor those making high level salaries in certain industries, this might shut out individuals like Ravi who are trying to get an H-1B work authorization so that they can stay in the United States. So we'll see. That's something we're keeping an eye on. And then what happens is lottery selections are done by the end of March. So in April, we know who's selected. And then April through the end of June, employers will work with Immigration Counsel or their internal resources to prepare an H-1B filing, get it submitted to the government. And then if that application is approved, the H-1B visa is valid for initial use not until October 1st of that year. Why October 1st? Because that's when the statutory numerical limitation resets. October 1st is the start of the government's new fiscal year. So that's how the H-1B category works. The good news is that once an applicant is selected against that cap, they don't have to go through the lottery process for their renewals. There are certain cap-exempt institutions, so universities of higher education, government research organizations, and nonprofits that are affiliated to universities of higher education are all exempt from that lottery system. Teaching hospitals are exempt from the lottery system usually. But for the most part, this is a very restrictive process. The private sector would push often for additional H-1B numbers, especially for those who are in STEM fields. And I think the reality that we often see is U.S. educational institutions, together with the U.S. educational institutions, aren't necessarily churning out an American-bred STEM workforce to keep up with all of the constant advancements we're seeing and the need for the private sector to hire well-qualified individuals. So kind of an interesting discussion. We're going to move along, but the H-1B category is a great visa if you're selected in the lottery. Going back to individuals who are working in OPT and STEM OPT, while employers might be able to hire them for 3 years without technically needing sponsorship, we do recommend that their name is tossed into the lottery on an annual basis, because again, the odds are not in their favor of being selected. And so having more than one bite at the apple can often keep or help elevate an individual's opportunity to get that H-1B. So Ravi's lucky, his H-1B lottery registration is selected, his employer files a petition, and it's approved. H-1B is issued in 3-year increments, and it's generally capped at 6 years. Extensions beyond that 6-year cap are possible if there are certain points the employer reaches in the green card process prior to reaching that 6-year cap. So we'll talk about that in a moment in a bit more detail, but I want to chat about some of the other visa categories. We are then going on, so we also have the L1 for intercompany transferees. That allows applicants who are working abroad to transfer into their US affiliate office. That can be a great category for larger companies whose foreign nationals are not selected in the lottery. Maybe they'll transfer them abroad. The catch there is that the individual has to be working for the foreign affiliate office for at least a 1-year period, full time, before they can transfer back into the United States. This is a strategy we're seeing employers utilize when they have great talent who are just not getting selected in the H-1B lottery. The employee needs to be transferred in either a managerial or executive capacity, or in a specialized knowledge capacity, which we need to show lots of technical manuals and that the applicant has a really advanced knowledge basis and skill set that justifies the transfer. In other words, we need to explain why it's not feasible for a US employer to quickly train a US hire. We're bringing somebody in because of their highly specialized knowledge. Going back to some of those other categories, again, when we have Canadians, Mexicans, or Australian nationals, we may look at some of the treaty-based visa options. But overall, when it comes to work authorization options for foreign nationals into the United States, it's pretty restrictive to that one slide that I shared with you, especially when it comes to professionals. So going back to Ravi, we know that Bison Software is very happy with him. They now want to support him in the green card process. Again, the green card is what's going to give Ravi the permanent ability to live and work in the United States without restriction, without having to constantly worrying about, oh, he's reaching the end of his train car ride. How do we renew? But that's not an easy process either. So it does require sponsorship by an employer. If Ravi were to get married to a US citizen, perhaps his US spouse would sponsor him for a marriage-based green card. That's a great option and definitely a faster option than employment-based sponsorship for the most part. Otherwise, if an employer is willing to go through this, more often than not, they need to undergo a test of the US labor market. And so what this means is that the US Department of Labor, of course, wants to protect the American workforce. And so they've laid out this process. We call it the PERM green card process. And with that, they are going to require an employer to show how they cannot identify a qualified American worker who's able and willing to do the job that the employer permanently wants to offer to Ravi. So that labor market test is a bit antiquated, and it involves a very delicate balancing act. As an attorney, and I lead our perm green card team here at the firm, we are looking at the job offer, what's required as far as education goes, years of experience, what do the job duties look like, and what is the skill set that is required to hire someone into that role. We're also considering what our applicant has. What skill set did he have before? Because when we have an internal job description that says, okay, we require someone with a bachelor's degree and 5 years of experience to come into this computer engineering role, but then we see that Ravi was hired into that role with a bachelor's degree and 2 years of experience. Well, we know that the employer's true minimum hiring requirements are not 5 years of experience. It might be 2 years. So it's a very delicate balancing act of looking at the employer's true minimum experience requirements, knowing what the labor market's like in the area where the job's being offered. And then we go through a mandatory recruitment process under perm regulations. We're not going to get into the nitty-gritty of that. Again, some of the requirements are antiquated, like it does allow for a radio ad or a television ad, which we'll use to our advantage, perhaps maybe to limit the funnel of qualified applicants, because at the end of the day, we want that perm applicant to be qualified, but we also need to play by the rules and make sure that the employer is truly testing the labor market as set out in government regulations. So the perm process alone right now, based on various parts involving the Department of Labor, that perm step is taking nearly 2 years. Now, the Trump administration did create a team, if you will, to look at what the Department of Labor is currently doing. How can we become more efficient for employers so that they can lawfully sponsor foreign workers for a green card, but also protect American workers as well and make sure we're not undermining the hiring of an American. So again, a very delicate balancing act all around. Perm needs to be done very carefully. There's a lot of compliance factors involved. We love doing perms, so reach out if you have any questions about that. But let's say once the Bison software does that due diligence test with the US Department of Labor, what's next, right? So then we file an I-140 petition with another government agency. We're moving away from the Department of Labor and now working with an agency called US Citizenship and Immigration Services. We can file that petition for expedited processing and get that approval in as quickly as 3 weeks, or regular processing, it might be closer 8 to 10 months. Big variance there. And then the third step of the green card process is asking the government to adjust Ravi's status from that temporary train, that non-immigrant train, to the green card train, which is going to ride him off into the sunset. A few interesting things about green cards overall in our US immigration system. So the government limits the number of green cards that they will issue each year. And the way they divvy those up is through preference categories. So there are some ways that a foreign national can self-sponsor. It's limited to those who are really at the highest end of their field. They're well known. It's also limited to multinational managers and executives. So you'll recall I spoke about the L1 category for intracompany transferees. I like to call that green card category the EB1C for multinational managers and executives. I dub that as the L1 category on steroids. We need to include lots of proof of management on both sides, both abroad and in the United States. And again, those two companies need to be affiliated for immigration purposes. There, again, another self-sponsorship category, the EB1, if you will, is for individuals who are at the top 10% of their field in whatever that sector is. And that needs to be supported by lots of documentation. Our cases are yay high often for the EB1 green card petitions. And that may involve lots of publications, patents, proof that the individual is being cited by other leading individuals in that same industry. And then one of the really hot green card self-sponsorship tracks what's called a national interest waiver. It is a national interest waiver. And that's for individuals who are working in a field that is in the national interest of the United States. So we see this be a successful immigration strategy for those who are making big achievements, perhaps in engineering and STEM fields. We like to see patents, again, publications, work being cited by other industry leaders, maybe some leaders in healthcare who are making some groundbreaking achievements, but those individuals may not quite be EB1 caliber. So limited self-sponsorship opportunities, more often than not, the most popular way to get an employment-sponsored green card is through the perm process. With layoffs, especially in the tech sector, we've seen a bit of a slowdown in perm sponsorship. Employers, it's not a great look if they're laying off their employees, but then sponsoring foreign nationals for green cards. So lots of competing interests. If you're interested in this, please do reach out. And then the second half of this presentation, I really want to talk about the compliance landscape for employers. What are we expecting? What are we seeing? As immigration attorneys right now, we're spending a lot of time fielding questions and putting out fires for our clients. They're reading the headlines. They're trying to see, okay, what's true? What's being hyped a little bit by media? The enforcement landscape, it's shifting very rapidly. And my message today for employers and HR professionals and global mobility teams who are listening is that you really want to make sure that you are adapting properly and staying on top of new mandates, especially for E-Verify, making sure that your I-9s are properly being done and re-verified. And if you are an H-1B employer, that your public access files are in order. So worksite enforcement is back in the landscape, and we're expecting to see, especially with the passing of the One Big Beautiful Bill, there are big increases to ICE's budget, and that's one of the enforcement agencies that is responsible for making sure American employers are in compliance with immigration sponsorship. I definitely am recommending that employers who have large workforces of foreign nationals, meaning non-US citizens, non-green card holders, are looking at their I-9 files, because the risk of non-compliance, it's not just civil and criminal penalties, thousands to hundreds of thousands of dollars, but it could also be debarment from visa programs and being able to sponsor H-1Bs or perm green cards. So it's definitely a good time to get your teams together, those who are stakeholders and are related to maintaining records and making sure that everybody's on the same page and kind of knows what to do. I want to get into a little bit of some I-9 practices and some of those fundamentals. So keep in mind, the I-9 is a form that is technically administered by U.S. Citizenship and Immigration Services, that's USCIS, and it's required for all employers to verify the identity and employment eligibility of new hires, including U.S. citizens who are hired after November 6th of 1986, technically. The I-9 rules are governed by the Immigration Reform and Control Act, that's IRCA. And again, civil and criminal penalties apply for non-compliance. That includes fines, debarment, criminal prosecution, and I-9s are subject to audits from several different government agencies, including ICE and Department of Homeland Security. So this is a priority for the current administration. I want to chat quickly through that form. I know some of you are familiar with it, but it's always good to remind on best housekeeping practices for this. So Section 1 is the employee attestation, and that is to be completed by the employee on or before their first day of work. They technically have up to 3 days to provide proof of employment. And this is where the employee is basically attesting to their identity. And when you have an HR professional who's reviewing and administering an I-9, you want to be sure that they are checking one of those following sections. I don't know, you probably can't see my mouse cursor, but in the middle, a little bit above the middle of that form, there's items 1, 2, 3, and 4. That's where the the new hire will check whether they're a citizen, a green card holder, or if they're a non-immigrant. And then section 2 is the employer's review of that information. And this is where they're going to look at the original documents that establish the employee's identity and work authorization. Now, an employer they have a reference list for acceptable I-9 documents. And for an American citizen or a green card holder, it's fairly straightforward. We're all familiar with a US passport or a green card, perhaps, or a combination of List B and List C documents, which could be a driver's license and a social security card. An employer cannot tell the employee which documents they will accept. So you want to be very careful when you're speaking with new hires and communicating this requirement with them. The list of acceptable documents is part of the I-9 form, and you can access that for free online. I recommend to my clients that they print this and give this to their employee, and that will help facilitate the conversation. Now, let's jump into some of the documents that you may see for a foreign national. Okay, List A is a document that proves both identity and work authorization. So again, that could be a passport, a US passport, pardon me. A foreign passport alone is not going to be sufficient for List A. It could be an employment authorization document. That's this red card, and the government technology for these cards is always changing, but that's something that is an acceptable List A document. It could be an I-94 record, which is the golden ticket for us immigration practitioners. That's for an individual who's been lawfully admitted into the United States in a certain visa category. An I-94 record, together with perhaps an I-797 approval notice that was issued by USCIS supporting their work authorization, that will work for a List A document together with the individual's foreign passport. A visa stamp alone is not always going to be sufficient. It might for some categories like an e-visa, but a visa stamp alone for an H-1B visa will not be sufficient. So again, you want to look at that itemized list of acceptable documents for I-9 purposes. And if you have questions about it, definitely reach out to a trusted immigration advisor, and we can very quickly help you work through that. And again, there's a delicate balancing act of not expecting or requesting specific documents from your employees, but when it comes to foreign nationals, an HR advisor can certainly facilitate that conversation and explain specifically what would be required or acceptable for I-9 purposes. If you have a foreign national who, this is an error that I often see for some of my clients who are not as savvy on the I-9 side. Yes, a driver's license and a social security card will generally work for I-9 purposes if the social security card is not restricted. If there is any type of annotation on the social security card that says valid for work only with DHS authorization, or there's sometimes some variance in how that is worded. But when you see that background print on a social security card, a takeaway today, that is not going to be suitable for I-9 purposes. And if your I-9 files are audited and you've accepted a social security card with that annotation as a List C document, that's technically incorrect. Now, you may still require a social security card, perhaps for payroll purposes. That is a common tension that we see in the HR world. But technically for I-9 purposes, a restricted social security card is not going to work. It needs to be unrestricted. And then for employers who are participants in E-Verify, those are the only employers who can require a social security card. Again, other employers may prefer it for payroll purposes, but you want to be careful there because you can't require specific cards to get that I-9 done. What is E-Verify? I don't know. Okay, so E-Verify is voluntary for most employers. It would be mandatory if you are an employer who is working on government contracts or and contracting with the federal government. Some states are requiring E-Verify. I don't know those off the top of my head, but it is not a system that is screening for immigration services. It is really just used to house your I-9 and to compare it to data that is in government records, namely DHS and Social Security Administration, to confirm an employee's eligibility. E-Verify employers have a lot of obligations, and I am always recommending that my clients who are E-Verify participants to annually review that MOU, that Memorandum of Understanding, and make sure that their work sites that are signed up for E-Verify and their users for E-Verify are constantly staying on top of system notifications and obligations for what's required as an E-Verify participant. Okay, now going back, overall, when it comes to I-9s, what are you certifying? You do not have to be an expert in immigration documents. The government is not trying to push that on you. But the reviewer is certifying that on its face, the document does appear to be reasonably genuine and related to the employee. So sometimes we see issues when there are discrepancies between the identity document and maybe the individual's name versus the name on the Social Security card. That's a reasonable question to ask. So I-9s can be a thorn in some employers' sides, but it's always good to revisit your policies and sometimes to do a self-audit, although that should be done carefully. There are some best practices, and that does go beyond today's webinar. We don't have time to go over all of those, but if there is a takeaway on this I-9 section of our webinar today, I definitely want employers to make sure that they have a solid system for flagging the re-verification of documents for their non-immigrant workers. So let's go back to Ravi, for example. Ravi's EAD for his temporary OPT and STEM OPT work authorization, that's always going to have an expiration date. And so the I-9 form will prompt you for the validity when documenting that item. And it's up to an employer to make sure that they are properly flagging the re-verifications and making sure that they are timely re-verifying the I-9 for those foreign national individuals who have temporary status. That my understanding is that E-Verify does not flag for re-verifications. So definitely keep this in mind and make sure that you have a strong process and you're calendaring appropriate timeframes to get this done. When it comes to re-verifying foreign nationals, those rules can get pretty wonky. There are receipt rules for pending benefits because immigration agencies take forever. Lots of questions can come up in tandem with re-verifying. And again, reach out to a trusted immigration provider if you have any questions about properly doing this. We can usually quickly look at documents and help employers navigate this part of their compliance obligations. And one last note on hiring H-1B employees. Part of the H-1B sponsorship process does involve the maintenance of a public access file. A public access file is an employer's obligation to maintain when hiring any H-1B employee, and it includes a copy of the LCA, which is a labor condition application that's given notice to the public that this company is hiring an H-1B employer. It's also making sure and showing or documenting that the H-1B employee is paid a fair wage for the job. And then, of course, employers who terminate their H-1B employers also have an obligation to notify the government that that individual, whether it's through layoff or a termination through cause, they are no longer working for the company. So that is an obligation for employers. For H-1B employees who are being terminated, there's a very recent trend where USCIS is issuing a document called a Notice to Appear, an NTA, and it's basically calling a terminated H-1B worker into immigration court for an appearance. I don't want to get into the nitty-gritties of these, but it is complicating immigration status for H-1B workers who are unexpectedly terminated. And so if you happen to be an H-1B worker in that situation, you definitely want to connect with Immigration Counsel to discuss what your options are when it comes to being unexpectedly terminated. And if you are an employer for an H-1B employee, you want to make sure that you are also maintaining compliance and notifying the government properly of that end of employment. Okay. We do have time for a few questions. I know that there are a lot of, oh, I'm sorry, before we dive into that, let's also talk about site visits, which is a common thing right now, and we're certainly seeing an increase. I have a slide here on some best tips for employers to protect their rights when a government officer shows up at a door. It's always best practice to have an assigned individual within the company, or maybe a team perhaps, who are prepped in advance on how they should engage with government officers. You are able to request and verify officer identification before answering any questions. Different officers from different agencies will have varying purposes of their visit. It could be an H-1B public access file compliance check. It could be a fraud investigation, or it could be really just a random site visit. So you want to be sure that the team handling this on behalf of an employer knows how to respond. Always be polite, but you do have the rights to, ask and take down that agent's name and request what they are asking for. So we have lots of resources for employers, and I can share that with the MP team, and that can be distributed to listeners as well if that's something that you're interested in. So we're heading to the end. I do want to take a few questions that came in through the chat. We have about 8 minutes. Before I do that, this is a QR code to connect with me on LinkedIn. My team and I are constantly putting out content. Berardi Immigration Law posts regular blogs and resources on all of the hot things that are happening in immigration. Again, we primarily focus on business immigration with a little bit of family-based immigration, but we're constantly talking about all of the new things that we're seeing come out under this current administration. So please connect with me or follow along. Everybody's welcome. And then our team also has, this is my managing partner, Rosanna Berardi. She also puts out a weekly immigration podcast, and they are about 10 to 20 minutes tops of certain hot factors that are going on in our immigration world. And we're really breaking down the facts, kind of reading in between both sides of media hype, the administration, and what they're actually doing to provide clarity on what's really going on. So this is a QR code for that. I'll go back to my LinkedIn page, but please like and follow the firm. Again, we are very passionate about providing factual information and not trying to buy into the hysteria. But understandably, this is a concerning time. We're seeing so many unprecedented changes in immigration all at once at a very fast level. So if you're looking for fact-based reporting, please give us a follow. And now for some questions. One of the questions I had was, to get the full 3 years of OPT, doesn't an employer need to be enrolled in E-Verify? That is true. So any US employer can hire a foreign graduate on OPT. But if you're going to continue hiring them for the additional 2-year extension, and remember, that's only available to STEM workers, the employer does need to be an E-Verify participant. So that's a great question. Thank you, Alan, for adding that. We also have a question asking about the possible salary component for H-1B subject to the lottery, how that will impact cap exempt filings. We really don't know. We are not quite sure what that's going to look like. What I can tell you is that the Trump administration did put out, the first administration attempted to change how H-1Bs were selected, and they tried to increase the wage scales without getting too technical. The Trump administration basically tried rolling out a different variation of this. It flopped. It did not carry through. So I would expect this time around they're going to be a bit more strategic. I will say that to make any substantial change in rules, the proposal would need to be published in Federal Register and then passed. So we'll see what that looks like. Again, it's an issue we're very closely monitoring because a major change will impact both a lot of employers and H-1B current visa holders as well. Someone asked if I could talk about the recertification for both U.S. citizens. I think that may be referring to re-verification for I-9 purposes. Let me clarify. U.S. citizens and green card holders should never be re-verified for I-9 purposes. So going back to that page 1, if they are checking that they are a citizen of the United States or a lawful permanent resident of the United States, or even I think that second one is non-citizen national of the United States, whether they're showing a passport or a U.S. birth certificate and a driver's license, or a U.S. birth certificate and a social security card, that is not going to justify a re-verification. Re-verification is primarily limited to non-citizens, or if you are bringing back an old employee that you had terminated within, I want to say it's the last 3 years. Don't quote me on that. And if you'd like to shoot me a specific question on that, Lori, I'm happy to do a little bit of digging, but I will double check on that. If the Social Security card is restricted and they have an employment authorization card, can you accept it? Absolutely. So the employment authorization card, bear with me, is going to look like this, that red card at the top that says United States of America Employment Authorization. And that's also going to be a column, let's see here, a column A, a list A document that you're going to put here. So you do not need to also put down their Social Security card because that EAD alone satisfies both identity and employment authorization. However, you are going to take note of that expiration date on the EAD and you're going to want to re-verify that. Okay? Do current employees need to be e-verified if you've only just enrolled in e-verify? My understanding is that is a no. My understanding is that e-verify is on a go-forward basis, but double check the current rules in your memorandum of understanding when you register. I do not believe it is retroactive. It is on a go-forward basis. Do you need to recertify an I-9 if the employee provided a green card that expires in 5 years? No, you do not. Green cards will have an expiration date. Almost every green card will have an expiration date. And that is because the government wants to make sure that there's tons of fraud and copycats, and they're currently always updating the technology that's built inside of those cards. They are also making sure that green card holders are abiding by laws. And so green card holders, similar to a driver's license, there is a renewal application involved. But for I-9 purposes, you do not need to recertify or re-verify a green card holder. And then someone asked about public access files and where they should be saved. So again, public access files are related to H-1B employers when they are sponsoring and filing a labor condition application. My big tip for public access files is to keep that separate from the employee's personnel file. And the reason for that is because if a government officer shows up and they want to take a look at your public access files, you don't want to give them somebody's entire personnel file. So if you have a big H-1B workforce, keep a separate process going, keep a separate location. Public access files can be digital. Kind of winging it off the top of my head, you need to have a signed certified LCA, proof that that LCA was provided to the employee. You want to include how the wage determination was made. And usually if you're working with Strong Immigration Counsel, we provide our clients with that documentation. We show what the wage scale is for the geographic area. We show what standards are in terms of what's an acceptable wage rate. An employer may add their internal wage documents and wage scales for that particular industry sector. But yes, great question on public access files. Keep those separate from personnel files, and they can be paper or they can be digital. It's up to you, but have a good process in place for maintaining compliance. Someone asked, besides the H-1B, what is dual intent? So dual intent is a complex concept. And what that means is that certain visa categories on that non-immigrant train allow explicitly for what we call dual intent, meaning that an individual can pursue a green card without there being any conflict in being here temporarily versus being here permanently. The H-1B and the L-1 visa categories in immigration regulations explicitly allow for dual intent. However, and this is one of my pet peeves as an immigration practitioner, just because a visa category like the TN or the F1 or the O1 does not explicitly allow for dual intent in the regulations, it doesn't mean that individuals in those categories can't also be sponsored for a green card. It does mean that the timing of certain filing milestones within the green card process need to be done strategically. And it does mean that there may be limited international travel for an applicant by the time they reach a certain point in the green card process. But just because a candidate who is here in temporary status that does not explicitly allow for dual intent, it doesn't mean that they can't pursue a green card. So if you're being told otherwise, definitely reach out. I have a lot to say about this topic. I know we're reaching the end of our time together. So Katie, please jump back in, but thank you all for having me. I've had a blast sharing my knowledge with you, and please fill out Katie's survey, because we can certainly come back and meet again, and we can specify some topics and continue to educate and share knowledge as you're interested in. So thank you for having me.
Yeah, thank you so much, Jennifer. We cannot appreciate you enough, and the knowledge that you've poured out to us. So, but thank you all too for joining us today, because we appreciate your time. I know it was a little bit longer than usual, but that's perfect because this was such great content. And again, you can qualify for term credits if you stayed over 15 minutes. And as a reminder, we will be sending out the recording of the presentation along with the slide deck this afternoon. So keep an eye on your inbox. I did just drop a link into the chat for the post-webinar survey and for some upcoming webinars that we have coming up. The Big Beautiful Bill, there was a glitch, but I think we've got to figure it out now. So you should be all good to register for that. And again, fill out that post-webinar survey. It'll give us an idea of what resources to send out and to create from this webinar. So thank you again. And before you go, we'd love your feedback. So if you could only just take a minute, I know I sound like a broken record, but fill out that post-webinar survey so we can continue to build out amazing content on behalf of all of us. So on behalf of MP and behalf of Jennifer and her team, thank you all for joining us, and we'll see you next time.